Good morning, everyone, and welcome to the Juris Project Sensitization session on the revised model guidelines for sexual offenses cases in the Caribbean region. So for those that may not know, the Juris Project, the Judicial Reform and Institutional Strengthening Project, is a multi-year Caribbean judicial reform initiative funded by the government of Canada, and implemented through the Caribbean Court of Justice. The project aims to support local jurisdictions in the region towards attainment of the project's ultimate outcome, which is a judicial system that is more responsive to the needs of women, men, youth, and poor. So the model guidelines is one of the initiatives that has been supported by the Juris Project. It was initially drafted and launched in 2017, and it was based on a research that was conducted in 2015 that found some major gaps in the justice chain for sexual offenses. Some of these gaps included poor investigative and evidence gathering procedures by the police, long delays in the completion of cases, undervaluing of sexual offenses cases in relation to public interests. So there's limited resources dedicated to sexual offenses cases versus other matters that were considered serious crimes. The research also indicated a lack of data collection to form the basis of monitoring and accountability of the court's performance. And there was insufficient interconnectedness between the courts and other key agencies that responded to sexual violence in the region. And finally, a major gap that was discovered was that for many survivors, they often made the decision not to pursue the matter for fear of re-victimization through the court process in terms of seeking justice. And so the guidelines were crafted to help to address some of these issues, and primarily to provide an internationally best practice for the management of sexual offenses cases, and to ground the adjudication of sexual offenses in a rights-based approach to the treatment of complainants and vulnerable witnesses, including children. The model guidelines aim to increase public confidence in this justice system as it relates to handling sexual offenses cases, to improve responses to survivors so that they can fully participate in the justice system and increase offender accountability. It also aims to reduce secondary victimization and to ensure a trained and skilled cadre of professionals, including judges, court staff, police, and attorneys, to be able to respond effectively. Another major goal of the model guidelines is to reduce the length of time it takes for the adjudication of cases and to reduce case backlog over time. So it's been 5 years since the guidelines have been launched, and they have been fully implemented in Guyana and Antigua and Barbuda. Antigua has a sexual offenses model court, while in Guyana, for my latest information, they have established 3 specialized courts for the response to sexual violence that serves both adults and children. So this year, the project thought it would have been a perfect opportunity to have a review of those guidelines, to examine if there are rooms for improvement, room for strengthening, in keeping with new and emerging best practices within the region and internationally. And this process involved a continuous stakeholder engagement over the last 2 months. And we'd like to really thank those partners on the ground that has given us really valuable feedback on how the guidelines have been working in the last couple of years and the areas that they may not have been so strong and where those improvements can be made. So our consultant, Ms. Diana Shaw, who's facilitating us today, had a review of those guidelines and worked on strengthening the human rights language to include recent innovations and best practices in adjudicating sexual offenses cases. We've also relooked at reframing the role of restorative justice and to include some guidelines to help judiciaries establish their own specialized courts for sexual offenses cases. So our facilitator today is, as I mentioned, Ms. Diana Shaw. Diana has a background in sexual and gender-based violence. She is based in Belize, is an active member of civil society also. And Diana actually worked on the first development of those guidelines in 2017. So really the work that she's done with us this year is building on that previous work. Diana has a master's in public policy and a bachelor's certificate in law with over 5 years of legal practice, social development, and working across the Caribbean region with regional and international partners. She has over 10 years of experience with stakeholder engagement, with advocacy in terms of gender rights, gender justice, and responding to sexual violence. She's an expert in access to justice for women and children, and has worked across the region in shaping sexual and gender-based violence policies and programs. So we're really happy to have Diana with us. She has a wealth of experience and expertise in this area, and has really led in the development of a much stronger product. Before I hand it over to Diana, I would just like to welcome everyone in the room. Justice Rajnath Lee, thank you for joining us. Justice Rajnath Lee of the CCJ has really been integral in providing guidance, advice, and advocacy around the work of the Mother Guidelines for Sexual Offenses. She has remained committed and present in this process since its initial inception in 2017. So Justice Rajnath Lee, thank you once again for your contributions. And I also like to thank, the other judges in the room who have been engaged within the review process. For example, Justice Anne-Marie Smith, that is assigned to the Sexual Offenses Model Court in Antigua, has been working closely with us in providing feedback, and also Justice Antoinette Moore in Belize has really demonstrated an interest and a deep interest in also working with those guidelines and providing the project with feedback in terms of strengthening it. Thank you again for joining us, and I'll hand you over to Diana. Diana?
Oh, gosh. Thank you so much, Salima. And thank you all for joining us. It is certainly a pleasure to be here with you again this morning. As Salima mentioned, this is my second round of working on these guidelines. I was the consultant that worked on the preparation of the original guidelines, and it is certainly a joy to be here again in the review process and to be able to document the progress that has been made, but still be able to gather the input of all of the participants to build on that progress, and also to craft some new guidelines that will support even more growth in this area going forward. So what we're going to be doing today, in the initial invitation, a copy of the agenda would have been shared with you. We are going to be doing pretty much an overview of some of the main aspects of the guidelines. Some of you who were a part of the stakeholder consultation would have already seen the changes that have been made and been a part of the discussions on the revision. What we want to do today is to sensitize the judicial officers as well as the court administrators, who will be the primary ones utilizing these guidelines, on the different aspects that it can contribute to the practice, and also the laws that you already have and some of the practice directions that have already come out. And the hope is also that this will help, as Salima has indicated, to those jurisdictions that are thinking about establishing specialized sexual offenses courts, that this will be something that they can use to frame that. Before we get into it though, we'll just like to give you an opportunity to introduce yourselves so that everybody can know who is in the room. So we will start with Justice Rajnath Lee, and then we will have the other judicial officers introduce themselves, and then the court administrators. Justice Rajnath Lee.
Thanks very much, Diana. Are you hearing me?
Yes, we're hearing you.
This COVID has some of us at home, some of us at work, some of us had to convert a bedroom into an office, which is what I have done. My boy's bedroom I'm in, but it's a nice place to be. I'm Maureen Rajnath Lee. I'm a judge at the Caribbean Court of Justice. I'm just thrilled to be here, Diana, and I know we did these sessions in person many years ago when we first had the guidelines. I'm so really interested. And congrats to you and Salima and Juris for all the great work you all have been doing. I'm happy to be here. Thank you.
Thank you so much, Justice Rajnath Lee. Then can we have Justice Smith?
Hi, good morning, everybody. I'm very happy also to be here. We have been implementing the model guidelines in our court in Antigua and Barbuda, and we are seeing some good results. There's a lot of work to be done, but we continue on the road. So I'm very happy to be part of this review this morning. Thank you.
Thank you so much. Justice Moore.
Good morning, everyone. I too am very pleased to be here and very happy that we're at this stage of the revision in the model guidelines. I'm looking forward to a pilot project that we're going to have in Belize with respect to a specialized sexual offense court and using the revised model guidelines and the examples from the other jurisdictions to lead us forward in this. So looking forward to the day.
Thank you so much. Justice Beyer.
Good morning. I am obviously the newbie to this process. I am the newly appointed judge of the family division in Antigua and Barbuda. So Justice Smith is my colleague on the bench here in Antigua. I don't have a direct input in relation to or even dealing with individuals who have these particular problems or these particular issues that these guidelines deal with. But I did do that in BVI when I was sitting on the bench there in the criminal division. So it is something that is a very going to be quite useful and of interest to me as well.
Thank you so much for joining. Justice Maurice Ramlal.
Good morning, everyone.
Good morning.
Justice Simone Morris Ramlal from the High Court in Guyana.
Thank you so much. Salima, do we have other judicial officers? I'm not seeing any other. Are there any other judicial officers that we did not see that just joined us?
We have a magistrate scarce, if he's able to hear us in the room.
Thank you,
Magistrate
Ms.
Scarce,
Bacchus.
go ahead.
Morning, everyone. Good morning. Senior Magistrate Sunil Scarce, Guyana. I know for a fact that we don't deal with and preside over jury trials as magistrates, but the original model guidelines, if I might term them that, I know how useful they have been in terms of debunking rape myths. We've been in training before in which Justice Ramlal has pointed out how useful she's found them in her deliberations and summing up to jurors. And I'm optimistic that this sensitization session today will also be extremely useful to us all as judicial officers and staff. Thank you.
Thank you so much. I see Justice Cornelius has just joined, so we'll just invite you to introduce yourself, Justice Cornelius. Your mic is muted, Justice Cornelius.
I was having some difficulty getting on. I'm Justice Jacqueline Cornelius from the High Court of Barbados. I think everybody here I know, and it's good to see you. I was involved in the original drafting of the model guidelines. I've done quite a bit of training around these guidelines from my judiciary and for DPPs and Crown Council in Barbados, and I'm very happy to be here again doing the second round, although I wasn't as much involved in this second round, but I am very happy. And with Sunil, who is there, and probably some others, I don't know who else is there. We also visited under the auspices of the UN, and also Juris, we went to South Africa to see their adjudication of sexual offense matters. So I have a deep interest still in this area.
Thank you so much. Now we'll invite the court administrators. See, we have personnel from the Guyana court who have joined. Can you introduce yourself and let us know who is representing from the Guyana court? Go ahead.
Hi, good morning.
Good morning.
I am Marlene Humphrey, legal clerk 2. I am the clerk attached to Principal Magistrate Cheryl Isaacs Marcus, and I'm representing you from the Guyana's jurisdiction.
Thank you so much. I think we also have Ms. Oticia Niles.
Good morning, everyone. My name is Oticia Niles, and I'm the registrar attached to Justice Simone Morris Ramlal, and I'm from Guyana, the Guyana Court.
Thank you so much. I see Mr. Marcos is it Cheryl Isaacs Marcus is on, so can you introduce yourself as well, please?
Hi, good morning, everyone. Cheryl Isaac Marcus, Principal Magistrate, Guyana. It's a pleasure to be here.
Thank you so much. Ms. Correa.
Good morning. My name is Sharon Correa. I'm the principal clerk of court for the Georgetown, Guyana.
Thank you so much. We have, is it Miss or Mr. Duncan?
Good morning, it's Miss Duncan.
Yes. Go ahead, introduce yourself.
Hi, good morning. Miss Leona Duncan, Deputy Registrar of the Supreme Court of Belize.
Thank you so much for joining.
Thank you for the invitation.
Hey, Joseph.
Hi, good morning, everyone. My name is Karen Joseph Josiah, recently attached to the High Court of Justice in Antigua, and I'm grateful to be here.
Thank you for joining us. I think that's everyone. Is there anyone that we missed? Dirk Harrison.
Good morning. Good morning, all. My name is Dirk Harrison. I'm a consultant who is presently working through the Attorney General's Ministry in Belize. I am working on a project sponsored by the UNDP, looking at the prosecution of serious offenses in the Supreme Court of Belize. Thank you very much.
Thank you very much. Ms. Humphrey. Can you introduce yourself, Ms. Humphrey?
I would have already introduced myself. Thank you.
Can you tell us which jurisdiction you are in?
Hi, good morning again. I would have already introduced myself. I'm from the Guyana's jurisdiction, legal clerk 2, clerk to the principal magistrate, Shirley Isaac Marcus. Thank you.
Thank you there. Thank you for joining us and reintroducing yourself. Is there anybody that we missed before we get started?
Good morning. My name is Crystal Delaney, a prosecutor here in Barbados.
Thank you so much, Ms. Delaney. And thank you all for joining. And now that we have a feel for everyone who is in the room, we are going to be getting into the main activities. We are going to be presenting some of the aspects of the model guidelines. As you can imagine, because of time, we will not be able to go page by page through the document. You have been provided an e-copy of the document, which we do hope that you have had a chance to review because it will assist you greatly in following the discussions that we will have. We will have some breakout activities to discuss some specific portions of the guidelines where during the consultations, we had a lot of input from judicial officers about different approaches that were happening in the region. So we'll give you some opportunities to discuss some of that and to see how you can, if you are not already implementing the guidelines, use this as an additional tool to assist the work that you're doing. The guidelines are not intended to replace any legislation or practice directions. We have had quite a bit of input from the judicial officers on the ground to ensure that the guidelines complement the existing legislation, the existing practice directions that are already in place in the region. So the guidelines will not displace or substitute any of that. It is intended to be an additional tool to enhance the work that you are already doing. So we want to begin first by just looking at a quick view of what we hope to accomplish today. The first part of the discussion this morning, we're going to be talking about case management both in the magistrate court and in the high court, the importance of this in sexual offense cases, especially as we focus on survivor care and protection as part of one of the thematic areas that run throughout the guidelines in ensuring that we balance both the rights of the defendant and the complainant. And then we will have a short activity to discuss some guidance around bail and how we use timelines in the court. Then we will be breaking for lunch. You will have a 45-minute lunch where you get to go off camera, and then we will come back to discuss the guidelines that are presented for the trial process. There is a focus on judge-alone trials, unrepresented defendants, the use of special measures, and then we'll have some discussion about summing up, and then we'll look at guidelines for sentencing, particularly around sentence indications, determining sentences, and then how we address non-custodial sentences. That is now something that is happening in some of our jurisdictions, and also how we address juvenile offenders who are convicted of sexual offenses. Then we will finish by looking at how the guidelines can support you in establishing a specialized sexual offenses court, if that's something that your jurisdiction is contemplating, or how you can strengthen an existing court in your region. And then we hope to close by 3. So let's get started first looking at case management. So this is the first part of the guidelines. You will see the directions about case management in the first part of the guidelines dealing with the pretrial process and also establishing a slew of different aspects of the pretrial process that need to be considered. We began in this initial revision of the guidelines to present a graphic with an overview of the justice chain process. This was something that came out of the consultations that we wanted to make sure that the guidelines show that there is a connection to what is happening before the court process, the law enforcement response, that there is a connection to the work of the social services agencies to the judicial process. And it's very important that the guidelines are seated in that especially as we look at sexual offenses and the role of victim care and protection, because that is such an important emerging feature in the region. Several of our jurisdictions now have specific legislation, such as Belize in the Protection of Witnesses Act, both specific measures that are required to be taken. Belize has also now instituted guidelines for the police, the commissioner's rules that give certain specific directions that have to be taken even from the point of reporting. Antigua as well has reformed quite a bit of their policies and procedures to create a more closer connection between the process of the law enforcement agencies and the adjudicative process and the post-adjudicative process in ensuring victim care and protection. So this is something that is now a feature of all of our jurisdictions, and it is being highlighted in a greater way in this revision in the guidelines. And so we will start with this graphic that shows that the justice process, the justice chain begins from the point of reporting the matter to the police, the work that the police do in investigating, the work of the prosecutors in deciding what charges should be brought to court. All of that influence what will happen in the adjudicative process. And though the guidelines are primarily intended for the court process and the court staff, their work is influenced by these prior processes. In the original model guidelines, we had also developed booklets that had guidance for police officers and things like the forensic interview and ensuring victim care and protection during that process. And we had also developed guidelines for the forensic medical exam. And those guidelines are still available on the Juris Project's knowledge management system. In the guidelines themselves, they will see indications in the footnotes of the links to that. When you receive the finalized version of the guidelines with all of the graphics and everything intact, you will also have active links to those management systems that you can directly access those products from the guidelines themselves. So it will allow the court to also have a greater oversight role in ensuring that when the matters are brought before them in preparation for their case management, that they can ask about these prior things that needed to have been done to ascertain who is a vulnerable witness, whether there is any indication of intimidation, all of those things. So that for the court to have that information, it's dependent on these prior processes during the investigative stage, highlighting and collecting that information. So those key stakeholders are also highlighted in the model guidelines. We need the work of the police to support the adjudication process in the reporting investigation stages, and they are working closely with the health and psychosocial service care providers in ensuring the victim safety and the care of victims, the assistance that they will need outside of the judicial process. The prosecutors, as I said before, who are the ones deciding what are the actual charges that are going to be brought to the court. And of course, the attorneys who are working for the defense, they're all a part of this process. The judicial officers who manage the court process and the court administrators are also key components of the justice chain. These are the main stakeholders that are responsible for the matters that come before the court as it relates to sexual offenses. So when we talk about case management, you will see in the guidelines, especially in the revisions, that we have increased the emphasis in highlighting the oversight role that magistrates must have in summary jurisdiction processes. We understand that these processes are intended to be expedited and much shorter than the high court process, and they may not specifically have allocated a hearing for case management. There is a recommendation in the guidelines that the first hearing of the matter should be used as a case management hearing, or to aerate those issues around case management, so that the determination of who is a vulnerable or intimidated witnesses, the special measures that they may need to facilitate them being able to give best evidence to the court, any concerns about any documents that are going to be needed. All of those things, there's a recommendation, a strong recommendation in the guidelines that those things need to be discussed upfront and specific directions given by the magistrate. For instance, if there are medical reports that are still pending, specific timelines should be set for when those reports are to come in. One of the things that came out of the consultations in all of the jurisdictions was the need to reduce delay, the need to minimize adjournments, and the need to ensure that the matters were moving through the adjudicative process and not staying on the books. And this was necessary both to protect the rights of the survivor, to ensure that the matters come to a conclusion and that they can work through whatever therapy they need to work through, but also to protect the rights of the defendant, to ensure that they're not held on remand for long periods of time without getting a determination of the matters that have been brought against them. So it is an important emphasis that's in the revised guidelines, that this oversight role must be strengthened, that magistrates must take charge of the proceedings from the onset, and that they must give directions about the times when matters are to be done, set specific dates, and the dates should be within a reasonable time. And they should also indicate from the onset the need to ensure that we keep adjournments to a minimum. They should be asking about the readiness of the prosecution, ensuring that they have whatever they need to get the matters moving, and so that we can move on. One of the other things that is also highlighted in the case management process is the need to address unrepresented defendants as part of the oversight role of the court and as also one of the protection measures. So I indicated before, Belize now has specific legislation that require this kind of inquiry, but where there is no specific legislation or where there is no practice direction requiring this inquiry, it should be done as part of the magisterial oversight, that they should ask unrepresented defendants and give a very strong recommendation that they seek legal guidance. If the jurisdiction provides for legal aid, that they are referred to legal aid. And if there is, we highlighted as well specific practices throughout the region in terms of setting timelines and in terms of addressing the issue of unrepresented defendants. One of the newer reforms that have come out since the last model guidelines, the criminal procedure rules of Trinidad and Tobago, they give specific timelines for when matters are to start and finish. And they give a number of extended powers to magistrates to ensure that they can have proper oversight and control of the proceedings. So if your jurisdiction is looking to reform some of the processes in the magistrate court as it relates to case management, this is a good best practice to look at. And it will also help, even if there is no legislation, for magistrates to have an idea of the kinds of things that you need to give direction about in your management of your hearing. In addition, as I said before, this idea of ensuring that unrepresented defendants, especially in sexual offense cases, are encouraged and urged from the onset of the proceedings to secure legal representation, especially for their cross-examination, is something that the guideline highlights. We also give two best practices that have emerged. One, coming from a practice in the sexual offenses court in Antigua, where the judge asks attorneys who may be present in the courtroom to volunteer to assist with the cross-examination. And we also have that happening in St. Vincent as well. In Belize, the new Protection of Witnesses Act, which was passed earlier this year, specifically prohibits an unrepresented defendant from cross-examining a vulnerable complainant. And a vulnerable complainant can include a complainant in a sexual offense case. So this is why the case management is so important, because the magistrate, the judge has to make that decision about who is a vulnerable complainant, what are the special measures that they're going to need, what directions need to be made about representation, about how cross-examination will be done. whether we need intermediaries, support persons, all of those things. Those decisions have to be made from the onset and specific directions given as to the time when those things need to be put in place so that the trials are not being delayed for long periods of time and to minimize the number of adjournments that will be needed to put these things in place later on. We have given you in the guidelines the link to the act from Belize, the Protection of Witnesses Act. And we have also highlighted that best practice from Antigua as something that other courts can do if there is no specific legislation preventing or prohibiting cross-examination by an unrepresented defendant. In addition, the guidelines give specific guidance about the different things that are to be considered as to how you decide who is a vulnerable witness. And some jurisdictions have legislation that give additional guidance on that, some do not. If your jurisdiction does not, then you can use the direction that's given in the model guidelines to assist you in that process. It also talks about the ensuring that these survivor care and protection needs. And we talk about, this is very important for sexual offense cases because there is, of course, much research and learning on the fact that persons who are coming to our courts in allegations of sexual offense cases, those complainants are likely to have trauma issues. They are likely to have issues that are going to compromise them emotionally, and the trial process is likely to trigger some of that. So there is an increasing concern throughout our region to ensure that those social services, the psychosocial support, are provided. Antigua and Barbuda, Jamaica in CISOCA, in its CISOGA organization, they have now interwoven these psychosocial support assistance tools and services as part of the process of care. And so it supports the judicial and law enforcement processes. In some of the other regions, Guyana, the courts have established partnerships with civil society organizations that provide this psychosocial support and also provide spaces and where victims of sexual offenses can have victim-friendly services and victim-friendly spaces, even to give evidence and also to receive other forms of psychosocial support. So it's highlighting the need that the magistrate needs to be aware of this and to inquire about this. And the case management process is the process when all of that kind of inquiry must be made, and the directions that are going to be necessary to facilitate if somebody is already having a support person working with them through the investigation or the law enforcement process to ensure that that continues in the trial process. Those directions have to be given in case management. It is also important, as I said before, that the court is looking also at how they can streamline the trial process. One of the big things that came out, especially as a result of COVID, is the need to ensure that we don't have these long delays and that things are moving through the process so that we don't create more backlog on top of the backlog that we already have of cases that have not been moving through the system. Several jurisdictions have begun to look at their statistical data to see that cases are lingering in the system for much longer than they should be lingering in the system. There are directions from cases that have been appealed coming from the CCJ that these long delays are not in the best interest of justice, and that we need to do more to ensure that the adjudicative process is efficient and that progress is being made to move things through in a timely manner. This comes back to some of the oversight role. Even where the magistrate is not responsible for processes that are outside of the court, for instance, the work of the medical examiner in presenting a report, it is important that the magistrate is using that oversight to set a specific time for when that should be presented and not just leave it up to the system to figure out when it should be done, because that's going to create unnecessary delay. The intention is that this oversight role will also put pressure on the law enforcement, the medical services to increase their efficiency in service in court. and providing the court with the documentation that they need for matters to get through the court system. What we have found is, especially in sexual offense cases, when matters take a long time to get to trial, witnesses get weary, complainants move on, and then they don't want to participate in the judicial process. And the work of investigators is either wasted, or the complainant does not achieve justice because there is no resolution to what has happened. And we sometimes end up with persons who are defendants being on demand for long periods of time before cases are thrown out. Those kinds of things are the idea behind requiring this great oversight, is to minimize and reduce some of that. Some of it we will not be able to eliminate because it concerns other entities outside of the judicial system, but it is necessary that as much as possible, judicial officers use their oversight role and the oversight powers, put pressure on the system to ensure its efficiency and that matters move with progress. So we give some guidelines about that in the case management, it's important for early identification of the real issues. And we talked already about the need to look at the needs of the complainant and also other witnesses, because the complainant may not be the only vulnerable person in the trial. There may be other witnesses who may have a disability, somebody who may have a trauma issue of their own that also requires support through special measures, and those things have to be iterated in the case management process. We also talked about in the guidelines, the fact that COVID has also changed some of the ways that our courts are operating. And I'm glad that the court administrators are here in the room, because this is the part that they will be supporting the court system. Some of our court systems now allow for electronic filing. Some of the courts now allow for remote cases. Some of you are still doing remote hearings. So directions have to be given for all of these aspects of the case from the case management process. So will we deal with documents that need to be submitted if everything is electronic? How will we deal with evidence that has to be presented? All of these things have to be contemplated. This idea of front-end loading and getting things up front is geared at reducing delay and minimizing efficiency and ensuring timeliness, but also it will help to contemplate the directions that need to be given, any objections that need to be dealt with at an earlier stage, so that we ensure that matters move along through the process quicker. In terms of the survivor care and protection component, there is an emphasis as well in the guidelines on highlighting some specific vulnerabilities that require more closer attention. I think all of the jurisdictions have now recognized the need to recognize trauma-induced vulnerability. But there are other vulnerabilities connected to disability. We are now seeing like indigenous persons in Belize having some vulnerabilities in the court system that also need to be looked at. And it is important that if the court recognizes this at an early stage, and the idea behind the guidelines is to be informed of this upfront so that the proper directions can be given. It doesn't mean that in all the cases the court will be providing services. In most of the jurisdictions, there is some collaboration with civil society organizations to facilitate survivor care and protection services and support that victims, the complainant and other witnesses, and it may even be a child defendant that needs some amount of support, psychosocial support and other services. Those are not necessarily going to be provided by the court, but it is important that they are contemplated and the directions are given. In terms of disabilities, for instance, we are seeing a greater emphasis in the region on the need to specifically protect the rights of access to justice for persons with disabilities, and the recognition that they are going to need special measures support, but also that there are other support that they will need in terms of the capacity of facilities. Some of our jurisdictions don't have facilities that are fully amenable to persons with physical disabilities. And if that is the case, then we may have to give directions for remote hearings, and let's decide what space they will be doing the remote link from. Those are things that have to be contemplated in the case management process. Similarly, there are specialized groups of persons. Primarily, this is happening now in Guyana. Guyana is also contemplating a specialized court that will be in the interior region, which will give greater access to persons from indigenous communities. And that court may look a little different from the other specialized courts because you may have other persons attached to the court that may be necessary in order to be liaisons between the communities and the court. What we are recognizing is that persons who live in indigenous communities in very many cases have a reluctance to come out of those communities to deal with authorities that are not connected to their community. There is suspicion of any authority connected to the government. Some of that has been fueled, for instance, in Belize, where they do have active cases against the government in relation to land rights. So sometimes that fuels some of that. But the courts have been able to build relationships with communities by working through civil society organizations, by having court staff that come from some of the communities, and by ensuring that the court staff are properly sensitized as to the different ways in which persons in those communities will perceive how they access the services from the court, and ensuring that it is done in a way that is sensitive to that. So it's important that there is this recognition that where you're in a jurisdiction that have these particular needs, then you have to make that kind of adjustment, because the goal is to ensure greater access to justice from the persons who will need to access the court. What we're finding that some of the guidance that the guidelines provide, specifically in relation to persons from indigenous communities, and in terms of indigenous communities, this can also be relevant to persons from other minority groups, persons who are minorities, not just based on ethnicity, but maybe based on sexual orientation, persons who are minorities based on other issues that are happening. You are aware of the particulars of your own jurisdiction, and the persons in your jurisdiction, religious minorities that may feel more isolated, that may feel more disconnected from the mainstream government services. You will be required to make this kind of inquiry in those kinds of cases when those persons are coming to access services from the court. So it requires an examination of how isolated they are, because that's going to tell you about their willingness to participate and their willingness to and even their understanding of the processes and the services that the court can and cannot do. The examination of any support persons that they have who can be these liaison persons to help to orientate them around what the court is able to do, the processes of the court, systems of the court, then also to help to expand their understanding of court processes, the examination of any specific trauma needs, any protection needs that they may have, especially if the complainant is also a person from that community. They're looking at the power dynamics between the complainant and that person from the community can give the court indications of the protection needs that may need to be put in place. Any language barriers and challenges for the court and for that person. They support systems like transportation, residence, if the court is not located near to the community. Those other practical things need to be discussed during the case management. If you're going to be using technological aids, the ability that they will have to connect to it. Not all of our remote communities in Belize, for instance, have good access to internet. So those kinds of things have to be discussed to ensure that you don't have challenges later on in the process. And then, of course, the similar consideration must be done at the High Court level. And in the High Court level, it's usually already done. It's important to ensure too that there are directions being given in relation to any special measure that's going to be contemplated. For instance, if you're going to be having a support person, the consideration of who can be a support person is important, not just because somebody is a family member or a part of the community means that they will necessarily automatically be a support person. The court has to be very clear that this person is not going to influence the person's being able to give evidence, that they understand that support doesn't mean that you are coaching the person as to what to say and those kinds of things. They understand that what they're there for is they're not taking over the court process for that person, that they're just here to support that person being able to access the service of the court. That's important. Those important directions must be given. If the person will require an intermediary, some of the jurisdictions mentioned and some of your judicial officers have indicated that they're seeing that there's a need for intermediaries to be screened and to be trained, because the intermediaries are providing an expert service in terms of they're the ones that the court uses to question a vulnerable child, for instance, who is of an age where they don't necessarily understand all the proceedings of the court. But that person may need to be trained as to the processes of the court, the language of the court, and the particular protocols of the court, so that they understand and can better support that witness that they are the intermediary for. Looking at how complainants will access the court to ensure that they don't come in contact with the defendant or the family members of the defendant is also important. There may be need to look at any restrictions on disclosure. If once you have declared that somebody is a vulnerable witness, for instance, in Belize, the Protection of Witnesses Act also now addresses some of those things that the court needs to consider. If you have an intimidated witness and you need to protect the identity of the person, how do you do that? Those are some of the things that you need to consider. And one of the other things that's coming out, the case management process should also give guidance to the attorneys that are going to be representing the defendant or the prosecution, and there's certain lines of questioning that are not going to be allowed. And of course, the court is not going to infringe on the role of the prosecutor and the defendant, but there is learning already coming out from the CCJ. There are some jurisdictions that now have that guidance in their criminal procedure rules that talks about certain things that the magistrate or the judge in a high court is required to give guidance on. And if you're going to address it in your summing up, you might as well preclude that from the case management process to give directions to the attorneys present that they are aware of that. If some of you also will know, in many of these cases, you may have concurrent family proceedings, because this may be a situation of a sexual offense that occurred within a family. And there may be matters that are going on at the same time concerning the custody of the child complainant in a sexual offense case, and the removal of that child and the termination of parental rights that is happening at the same time in the family court. It is important for the judicial officer to be mindful, to be asking about those proceedings in the case management process. Why? One, because you don't want to have conflict with dates. And two, because you want to ensure that if there is a care order in place to remove a child, that is actually being acted on and being dealt with while you are considering the protection needs, because it is going to impact what directions you give about contact, about the need to have the child in a different location, those kinds of things. So it is important to be asking those so that that information can be provided, so that the court can have all information that it needs to make whatever case management orders are required to ensure that the process is comprehensive and that you are able to address all of the issues that will affect the trial process. In terms of the protection needs, and this is where we have intimidated witness, not just protection because of trauma, but protection from tampering and from interference. That's also something that is a reality in all of our jurisdictions, some more than others, where the court also have to give directions about that. And there we'll have to look at the witness's age, and it's not just the complainant, it will maybe other witnesses in the case, the circumstances of the offense, the behavior of the defendant and their family members, any known threats or intimidation tactics that have been used. We can give protection orders. It can be orders prohibiting contact. It can even go as far as relocation of the witness, which has happened in some of our jurisdictions. Or the prosecutor may already have some things in place that they were doing during the investigation process that now needs to be cemented in court orders to be continued or to be expanded. So normally it is the prosecutor that will lead with that and make whatever application needs to be made. But what we're saying in the guidelines is that even if the prosecutor is not giving information about that, if from the reading of what has been presented to the court has a concern about that, then the court should ask. The court's oversight rule should at all times be manifested. That the court must be concerned with and ensure that the proper directions are being given and that proper information is being given to the court to support those directions. So I want to break you into 2 breakout rooms, and we're going to have a discussion on how we deal with bail proceedings, which are also usually coming up at the beginning of the court process. There are different considerations about bail in sexual offense courts in the Caribbean region, and we want to aerate some of that. So we are going to open up, we have 2 breakout rooms that we have assigned. Salima?
I'm here.
So I'm going to ensure that we have everybody in a room. Give me a minute. Let me just check on all the persons who joined after to ensure that they're assigned to a room. All right, we're going to open the breakout rooms, and I would say we can do 10 to 15 minutes of discussion. We have a scenario to spark the discussion, but the discussion is really to get you to think about the different things that you will need to consider in a bail application in terms of your survivor care and protection needs, and also any needs that the defendant may have in terms of ensuring that a child defendant, for instance, is adequately addressed in contemplating that. And then we will come back, choose a presenter, somebody that will present for the group. I will join group 2. Salima, you will be in group 1.
Are we going to get the case once we're in the breakout room?
So you have the PowerPoint already. I emailed the PowerPoint to you.
Oh,
and
okay,
then,
so I could use it.
yes.
Okay, great, thank you.
I will disable the recording for the group activity. And I will share the screen so that you can see the discussion that we want to have around this scenario. Is everybody seeing?
Yes.
Yes. I can see the screen.